Chapter 3, Character Evidence. In evidence law, we have this rule against character evidence. Character evidence can take two forms. One is reputation evidence. Another one is evidence of other acts. We can look at this example of a shoplifting case. And in a criminal case, by this rule against character evidence, we mainly mean the prosecution cannot introduce any character evidence against the defendant. As we said, this character evidence can take two forms. One is reputation, another one is other acts. Take this shoplifting case scenario, for example. Suppose the defendant is on trial for shoplifting. The prosecution cannot introduce evidence indicating the defendant has a reputation of being a thief. For instance, the prosecution cannot introduce a witness to court to testify that the defendant has a reputation of being a thief. The prosecution cannot introduce evidence indicating the defendant has committed similar crimes. For example, if the defendant is on trial for shoplifting, the prosecution cannot ask a witness to come to court to testify that the defendant in the past committed other shopliftings. So that is what we mean by this character evidence may take two forms. One is reputation, another one is other acts. Either one of these two forms of character evidence is not permitted. Now we need to look at why this in evidence law we have this rule against character evidence. The reason for prohibiting character evidence is this. Jury tends to give too much weight to character evidence. A point we need to emphasize is this. Character evidence is not admissible. It is not because character evidence is not relevant. Character evidence is relevant. Actually, in our life, we all use character evidence to judge other people's behavior. To take a simple example, if a person borrowed money from you and then the person would not return the money later, and then if next time, if this person would come to you to try to borrow money from you again, would you still lend the money to the person? Most likely you wouldn't. Why you wouldn't do it? Because you made a character judgment. You're going to think this person is a not honest person. Last time he borrowed money from me and then he didn't return that. Now he's going to borrow money from me again. Of course, I'm not going to lend money to him again. So in this thinking process, you're using character evidence. You are making a character judgment. But in this situation, we all know your judgment is not wrong, because if a person did a dishonest thing before, your judgment is going to be, it is likely the person may do that again. So in that sense, we have to say character evidence is very relevant. We have this rule in evidence law. We have this rule against character evidence. It is not because character evidence is not relevant. It is very relevant. And also, if we go back to this shoplifting example, if the person now is on trial for shoplifting, and if the person indeed in the past committed another 2 or 3 shopliftings in the past, you cannot really say this evidence of committing other shoplifting is not relevant, because if a person could steal once, and it is the likelihood would increase. The person may do the same thing again. So in that sense, we have to say character evidence is very relevant. It is not character evidence is irrelevant, so that we don't want to admit character evidence. Actually, to the contrary. Character evidence is relevant. But the reason we do not permit character evidence is not because it is not relevant. It is because if we introduce character evidence, jury tends to give too much weight to character evidence. Take this shoplifting case, for example, once again. If the defendant is on trial for shoplifting, according to law, the prosecution needs to present evidence beyond reasonable doubt, need to present proof beyond reasonable doubt to show the defendant committed this shoplifting in question. So whether the defendant committed this crime or not should be judged by one standard, that is, whether the prosecution has presented evidence indicating beyond a reasonable doubt the person committed this crime. That is a legal standard for conviction. However, if we permit prosecution to introduce character evidence, if evidence is introduced, if some witnesses, maybe defendant's co-workers would come to court to testify, the defendant has a reputation of being a thief, or maybe there's some evidence introduced indicating the defendant committed shoplifting before, that evidence would become decisive. If that evidence is introduced, the jury would not continue to try to look if the prosecution presented any evidence indicating on this particular occasion the defendant committed this shoplifting or not. The jury is going to think the person is really a bad person, and then it is very likely he committed this crime he is accused of. So, but in that regard, the jury would tend to overlook whether the prosecution has presented sufficient evidence indicating the defendant committed this particular shoplifting. So that's why we do not want to permit this character evidence. So legally speaking, we may say we have two reasons to for this to have this rule prohibiting character evidence. One is overvaluation, meaning is if a character evidence is introduced, jury tends to give too much weight to this character evidence. And another related reason is because of this overvaluation, jury tends to make a decision on improper basis. So that is another concern. But these two reasons actually are related. Take this case of criminal assault, for example. Suppose the defendant is on trial for criminal assault. The prosecution must present evidence beyond reasonable doubt, indicating the defendant committed this crime. But if suppose we would permit the prosecution to introduce character evidence, and then the prosecution may ask some defendant's neighbors to come to court to testify, maybe the defendant's neighbors would testify that the defendant is really a bad person in the community, is a big bully, and he would beat up other people. And if this kind of evidence is introduced, the jury would tend to disregard whether there is a sufficient evidence indicating the defendant committed this crime in question, this criminal assault he is accused of. The jury may think this person is a bad person anyway. So regardless whether he committed this particular crime, because he's such a bad person, did so many bad things, and then we are going to return a verdict of we are going to convict him, we are going to send him to jail because we are going to lock up a bad person. But we know if that is a thinking process of the jury, that decision is not based on proper basis. Because to have a person convicted, the only proper basis is the prosecution has a proof beyond reasonable doubt the defendant committed this alleged crime. The jury cannot make a decision based on the person's past behavior. The jury cannot say, now the defendant is on trial for criminal assault, but after we learned this person is really a bad person, so we're going to punish him, we're going to send him to jail. We know we can only punish the defendant or convict the defendant for what he did. On this particular occasion, jury cannot convict a person or punish a person based on what kind of a person that person is. If they cannot really say we are going to get the person convicted because in our judgment this person is a bad person, he did many bad things, so we are going to send him to jail, we are going to get him convicted. We know that is not permitted because in this criminal trial, the only standard we need to use to have the defendant convicted is whether the prosecution has proof beyond reasonable doubt that the defendant committed the crime he is charged with. So that is a reason why we have this rule against character evidence. It is important, once again, for you to remember character evidence is prohibited. We have this rule against character evidence, meaning is the prosecution cannot introduce evidence to attack the defendant's character. But character evidence is not permitted. It is not because it is irrelevant. Character evidence is relevant evidence, but we do not permit character evidence because we are concerned about this overvaluation on this evidence by the jury, and also jury may make this decision on improper basis.